All right, so I think we should be recording now. This is the second actual meeting. We had a meeting in between that was mostly a conversation, so I didn't record it. So this will be the second full meeting to talk about creation of OPDC delinquency performance standards. And so right now I'm going to share the so many tabs. Share the working document we have from the Dropbox of the marked up Oregon performance standards. And I think any of you should have access to it if you want to look at it, not on my shared screen. Let me see if I can. Delinquency performance standards. There we go. Is that showing up for you all? Great. So I don't know if the best way for me to do this, or for us all to do this, is for me to just kind of scroll. We're at 1.1. I looked through everything Nora and Ko had done, and I think that they did a lot of good work. But I don't know if anyone else has had a chance to look at it and wants to jump to something. But if not, I think it's fine to kind of just talk through whether this captures what we want. I think a thing we have discussed on the criminal side is what the difference between the bolded standard at the top and the implementation pieces are. And we had been considering the bold standard to be essentially the black letter and the implementation piece to be more like best practices, or recognizing that that there are certain things that are baseline that we don't really want to bend on, but then there's a lot in the standards that where we're asking a lot, and probably everyone should be doing it, but we also recognize that everyone has too many cases and not enough time, and the distinction between what's aspirational and what's baseline is hard to draw. But if these are performance standards that we would like ideally to everyone to meet, what is the difference between the black letter or what's currently just bold and implementation? And I don't. So that's been one conversation we've had, but I don't know if that's the best way to approach it.
Ellen, I apologize. This is the first time I'm getting a chance to look at this, so I apologize if I don't have a bunch to add to this meeting right now.
No problem. I mean, like I said, I don't. I know it's a lot already to ask you all to jump in on this, and so I don't expect you all to have a lot of free time outside to take a look. So I'm happy to just scroll through, but I didn't want, if everyone had looked at it and was like, yeah, keep going. I didn't want to waste time. Go ahead, Judah.
So I went through this, and I know that I would get into an absolute fist fight with Liz over this, but saying that you should also be following the NJDS standards without incorporating them, or say like making sure that there is no conflict between these standards and NJDS is, like I think people should be familiar with them, but I'm concerned about saying, hey, we're also incorporating this fully into the standards without actually fully incorporating them into the standards.
Do you think sort of a footnote with an attachment to the standards would work, or would you prefer like a bullet point list of what their standards would be?
I think either way, like if we're fully incorporating it, then we're dragging and dropping the whole thing in, or saying, hey, you should really, this is a reference that's helpful for fulfilling the standards that we've set forth.
Gotcha. So, and I mean, I kind of think you put the list in if it was, hey, this is mandatory, and maybe an attachment to a footnote to what to go look at if it was more suggestion or aspirational.
Yeah, I think that's a good point. Like if there are places where there, and I don't know off the top of my head if there's places where there's a conflict, it certainly doesn't seem like even if we are if it's mandatory, even if we drop it in, that doesn't work if there's some way in which they conflict, and I haven't gone through to see whether they do or not. I assume they don't conflict. What one might just be more stringent than the other, because I know that the state bar standards at least say that they were written with those in mind.
Well, the other thing is those, I mean, like I see it as being aspirational because that document, while I've gone through it and it is very helpful, especially when I was new going through that, is 166 pages long.
Yeah. Yeah, so maybe it is. Maybe we do think about it as aspirational with a reference to it, but it would be helpful to have a clearer reference to it, make it available.
I also, and this is only kind of related, but I guess if we're saying that the bold section is sort of the black letter baseline for the standard, and then other stuff is the aspirational part, is that clearly marked out in the document? Because if someone's coming in from outside and is unaware of the discussions going into the background, are they just going to read this and go, oh, I have to do every single thing here? Or is
Right.
it going to be clear that you should and we would like you to, and you have to do these things, but there's some allowance for the real world and some of these other things? Is that clearly marked?
Right. I think that's a great point. And right now, the answer is no, it's not clear. But I think if that's where we end up going, then yeah, we'd have like a preamble or something that explains all that. But we didn't want to put that because we hadn't discussed yet whether that's what we actually want to do. I think it is tough because in a lot of ways, as currently drafted, what's written as implementation is really clarification or about how you would do what's written in black letter. But there's other parts of it that seem like it is more, and it's hard to do all of it all the time. And I don't know. So yeah, I mean, I think it's a hard challenge. It's a hard challenge we're encountering on the adult side as well. So
Well,
I think
instead of implementation, we could just do it. NJDS doesn't call it commentary because they have the bold section and then they list out like how you do it in they call it commentary on the.
Yeah, I mean, I think it looks like the Oregon standards I know also have commentary that it looks like was that Nora and Ko must have taken out, which I think is also what we were planning to do on the adult side. And that commentary is more like commentary with like footnotes and explanation. And this is kind of like commentary, but is also kind of sometimes is explanatory and sometimes is additional. But maybe this is just something we can keep in mind as we go through and keep looking at the relation between the bold and the implementation and see how if we want to change how it's characterized. Welcome, Nora. We're just talking about the work you and Ko did and kind of thinking about not only what thoughts people have on it, but also how to think about what the difference is between the implementation section and the bold section, and whether the bold is black letter and the implementation is more aspirational, or if it's all black letter, which some people might chafe at in terms of expectations. If it's all, even though a lot of it is part of the current standards and people should be meeting it now, I think especially in places where we're adding, if we're adding a lot at once, there might be some concern about what it means that these are black letter performance standards. Does anyone have any additional thoughts either on that topic or about what's on the screen? If not, I can just scroll down and we can look at the next section.
So yeah, I actually have a thought, and you know, the stuff okay, the thing that are labeled implementation, like I don't know. I guess sorry, I'm not really making like I'm not even thinking terribly clearly, but those. I mean, what is labeled implementation are ways to provide quality and zealous representation at all stages of the case. I mean, they're not. I don't think they're aspirational or optional. I think that that's what quality and zealous representation in juvenile cases is. And no, we can't do I mean, nobody can do everything all the time. That's certain, right? But I don't want to, I just wouldn't want to give the impression that these things are optional, because they're not. Does that make any sense to anybody? I'm sorry. I'm also like I'm also gearing up to try to spank the agency later. So my brain is sort of back there. But
I mean, like, the only thing is, like, there's like we're always following our client's lead, and I'm just thinking of I had a particular case a few years ago where at initial appearance, where I had no discovery whatsoever, I had a client that was adamant that he did not want to review in any discovery, he did not want to explore alternatives, and he wanted to make admissions right there and then, and wouldn't be swayed off it, and that would be violating some of the standards. But I had to follow my client's lead that that's what he wanted to do. Like, that was the number one.
So it sounds like, Judy, you're saying that there are times when they are inherently contradictory.
I mean, that is that. I mean, like, I guess. I mean, that is sort of the practice of law, though, too, right? Like, that, like, we do have to adapt sometimes to what our clients are demanding from us, and sometimes be like, fine, you do you, dude. But
Hannah, can I jump in? I also
Yeah.
think that like in Judah's situation, he has to be able to analyze like if his client can aid and assist and in that moment and be in a position to make that intelligent decision, right? So there's more to it than just saying he wants to do this, so I'm gonna let him, right? Like, you also need to understand that like a lot more of the ins and outs of the situation.
yeah, absolutely, right.
I have a question separate from this topic. Since I've got the floor here, Colin. So like I think we're all going to probably come to an agreement on what the standards should look like. And I may be mixing up my meetings goals on some of this stuff, but was there an idea to make the standards such that they could be, I don't know, measured or like?
Yeah, I think we talked
I
about
don't want to
that.
say enforced, but like how?
Right.
Like these are all great, but how do we know that people are doing them? I guess is the question. Was that a question from the first meeting?
Yeah, it is an overarching goal to the extent possible, have standards that have at least some standards that are measurable and meaningful. And so if there are ones that aren't here that we could add in and measure, that would be great. The reality is, for most practitioners, the agency, even if something were measurable, doesn't have currently a way to measure, because there isn't timekeeping and we can't violate privilege. And so it would be limited to certain, I mean, even if there were timekeeping, it would, that'd be helpful, but that only addresses a very small subset of standards. Like, are you visiting your client within a certain amount of time? Are you visiting your client regularly? We might be able to see that if there was timekeeping, without violating privilege. But there's a lot of other stuff. I think maybe the fact of filing motions would be measurable, and a persistent non-filing of motions would be a red flag. But a lot of this, we want a lot of the standards. we want as many standards as possible to be measurable, but we also recognize that the vast majority of standards won't be measurable, but nonetheless are important and need to stay here. Does that answer your question?
I mean, sort of. Yes.
I mean, it's
because
unsatisfactory partly because the answer is unsatisfactory. I think the agency is struggling to figure out what it means to do performance oversight over independent contractors. I think we're the only state that's kind of set up this way, where the agency is theoretically supposed to do some performance monitoring, but doesn't have direct oversight of anybody. Well, I mean, has direct oversight of few people. And so that is something we're struggling with and grappling with. And maybe, there's the oft discussed future case management system the agency is developing, which might address some of this, but wouldn't address all of it. So in the end, our task is to create performance standards, and then also at the same time, if we can think about any that are here and could be measurable, to make sure to either highlight those, or if there's a way to add something in that would make it more easily measurable, we should try to do that. But I don't think it needs to be always front of mind.
I mean, I guess the answer would be it would depend how much you trust your contractors, right, to enforce the standards of the people they're hiring to do the work.
Right. I mean, and then we also have, solo practitioners.
Yeah.
So there's no one, there's no one doing oversight if it's not the agency, but the agency can't. So, we'll see. Was there something else unrelated to that before?
So the one other thing that I noticed here, unrelated to what we were just talking about, what's on this page, says including going through all discovery material with the client. And I mean, so does that include body cam? Because I have cases where I'm drowning in body cam, that there's no way I'm going to get a 14-year-old to watch 15 hours of body cam with me. That's not real.
So I think that there are strategies to deal with those particular issues too. Like, I use justice text to transcribe all of my body cam videos, and then I can highlight the portions of body cam that's relevant and show that part to my client. So because not all the body cam footage really is discovery, it's just background noise.
Right. Yeah. I mean, I guess that's sort of my point. Like, I review the material that at my discretion I think is important, but that's not all discovery material. That's the material that I have identified that I think matters. The dash cam of the cruiser going up to the scene. I mean, that doesn't matter. But I feel like the words don't necessarily capture that ability for you to make that call.
Agreed.
and decide what you review.
So maybe it should say including going through all relevant discovery materials with the client,
I think though the problem that I have with that is that technically speaking, the client has a right to see all the discovery, right? And while, as a practical matter, um, we may show portions of relevant body cam to a client because I think most clients, whether they're adult or youth, don't want to watch 14 hours of irrelevant dash cam. They have a right to do it, right? And so I sort of hesitate about putting into the standards that there's discretion in some way on the part of the lawyer, which would then abrogate the client's right if they want to see all the discovery. I also just wonder, if we're talking about enforcement of these standards or review of these standards, is if a lawyer, I don't know, standard says share all discovery with the client, and I'm just, to me, I guess I'm having a hard time articulating this, but I struggle with the idea of just saying relevant, because I think
Would
it is the client's right
would
to
it?
see all of it if they want to.
Yeah, I say would addressing that by saying make available all discovery and make available all discovery to the client and then ensure that you review relevant discovery. Because I guess what I do is I review the parts that I think matter, and then I tell the client, I have this much more, and I will give it to you to review if you want to watch it. I have
Mhm.
identified what I think matters. And so then that way I'm ensuring that they know they can have it and that they can look at it, and that
Mhm.
I have decided I don't think that it's important, but that it is their right? Like they can still do that. And
Mhm.
so I wonder if that would be a way to address kind of both things, that um, we're not required to watch all of it with them, but we're also making it available to them. I don't know.
Although for a client that's in detention, the only way to make it available to them is to be there with them when they're watching it.
Hi, everybody. This is Liz. I want to sort of weigh in on that issue. I've had a couple of clients who just told me they didn't want to watch the discovery, didn't want to review it, both because of the nature of what they were accused of doing, and another one who just didn't could never articulate to me that he was interested or willing, and we tried watching it and he just was not able to process it. So I wouldn't want, I would want some sort of room here, or some, if to address that situation where you have a young person who's accused of something and they are themselves traumatized, or still processing through what happened, such that they didn't want to look at the pictures, or watch the CARES video, or whatever it happens to be. So I've had adult clients say that too. So
yeah, if a client elects not to view discovery, I don't really see how that would be a violation of the standard, because you're following your client's direction, which is kind of rule number one in some ways. I don't know. How are they dealing with it on the criminal end?
We haven't gotten that far yet. Judah?
Just wanted to tack on to what Liz was saying. So I always say, hey, I provide my client, like, this is all the discovery that I have, and here's the ways that I can provide it to you. But for juveniles, it's particularly important. Like, you might have a young person you're working with who's not very adept at reading. And so making the discovery, like a police report, available to them means something different than it would for an adult, because I might write a summary and at a lower reading level. And so just to say, it does mean different things for kids to make sure that they actually can understand what they're reading.
I mean, I think that comes up in adult work as well. I don't know. I will say this. My practice is not to, if I can avoid it, give my clients copies of their police reports. I will read every single word to them, and if they absolutely want a copy of it, 100%, that's their right. I will give them a copy of their police reports, no question. But I've just had so many over the years circumstances come up where when you give them a copy, either they lose the copy and somebody else sees it, and and especially with kids, they don't necessarily want other people to read their police reports, and that they should, I want to help them sort of stay safe with that. But I also think that there's a lot of value to either reading police reports or watching videos with your client, because you get their reaction in the moment, and you can discuss things that they might not have remembered if you hadn't been there while they're going through it. That's more of a practice tip. I don't know how to incorporate that into these guidelines. But I feel like that's, I don't know, that was just how I was trained. And I find it is helpful with clients. So again, I don't know how to incorporate into this.
Yeah, I was just trained that you must offer, say that it's available, you must offer that you can provide it copies of everything to them. That I just have to. But yeah, I always go, I mean, if you're not going through a police report, they're never going to say, oh, but my friend Tim was standing off to the side recording it on his phone, and then you can go find Tim.
Right.
I mean,
I seem to remember there being parts later that might address some of this developmentally appropriate conversation piece. And I think the question for this number 4 we're talking about is whether, sounds like the question is whether whether it should just say make available, or what the distinction is between making available and reviewing in this context. But did I cut you off, Matt?
Sort of yes and sort of no. It's fine. I was just going to jump in with my practice tip, which is I always like to go over the state's evidence, like what's in the police report, before I ask my client what happened, or like what their perspective on what occurred, because then they're reacting to what the state's evidence is, and not, you don't find yourself in a position where they've told you one thing and then, oh yeah, actually it was this other thing or whatever. It's cleaner that way. You all probably know that on this call, but I just felt like I needed to say it out loud. Oh.
Did it seem like there was consensus around adding make available all discovery? And then I guess the question is, do we keep in going through? Because I mean, as maybe someone pointed out, I guess I think it was Liz, there will be cases where you go through almost none if the client refuses to engage with it, and that probably is not a violation. But if you've made it available and made it very clear that it's available, and then they decline after you've explained in developmentally the appropriate ways why it might be useful for them to look at it.
Yeah, I agree with that.
Yeah,
you have to make it available for all the reasons that have already been stated. I agree 100% with that.
My only concern is that you might encounter, if the standards are a little bit too open, and I'm sorry to sound cynical about this, I can definitely see lawyers just saying to their clients, well, I have discovery, do you want to see it? And the client taking the path of least resistance saying, can you just tell me what it says? Or no, I don't need to see it. And then the lawyer isn't can say, well, I made it available because I told them that it was here, that I had it. But that doesn't really, I don't think it really fulfills the lawyer's obligation. It's a different, I think it's a horse of a different color if a client is saying, I do not want to see the body cam. I do not want to see the autopsy pictures. I do not want to see A, B, and C, right? And I've definitely had that situation. I'm like, I'm not going to force you to watch anything. I'm going to, I can explain to you what it says if you really don't want to see it. But I think it's saying make available leaves this leeway where a lawyer could just be, well, I had it. I told them that I had it. They didn't ask for it. So we never went over it. And then that's not really effective representation,
Yeah, I was actually unmuting to say exactly that, Nora, like that these standards aren't being written for people for those of us who do this all the time and have practice tips to give and all of that they're really being written to outline what is expected in quality and zealous representation. And I mean, I agree with Nora just saying like, oh yeah, well, I totally made it available is not the same as a meaningful like a meaningful discussion and a review of and and I do think that that's what's required.
Mm-hmm.
Is it making available and attempting to review all relevant discovery material? Is that still not strong enough?
I don't think so. I don't think it fulfills the obligation because again, one, I don't believe in writing standards to the exception, right? Like the exception may be that you have a client that doesn't want to see it. That's an exception, but I don't think the standard should be written to the exception. I also think that I'm just thinking of, lawyers that don't review discovery. And again, I think if you say attempted, then it's like, well, it was on my computer. I attempted by asking them if they wanted to see it. They said they didn't want to. They said, no, that's okay. And so I made the attempt and I made it available. I fulfilled the standard. Is that effective? No. You know what I mean? Like there's just, it creates this space for ineffective assistance that's sanctioned.
I just pulled up the RPCs because I was like, okay, what is our baseline ethical obligation under the RPCs? And then as I was thinking about it, listening to this discussion, do I recall that there were some lawyers disciplined or a lawyer disciplined for not reviewing discovery somewhere in Eastern Oregon?
Not
Yeah,
downloading.
it was.
Yeah, not downloading.
I was in the same consortium as that attorney while he was doing that. And took over some of his cases after he was discharged from that. So
Okay.
yes, it was for about a year. He was not downloading the discovery at all, let alone reviewing it. In that county, they would do PC affidavits for arrest, and he was just reviewing those. Like the 2 or 3 page document, and pleading people out to years in prison. And I had a guy on a downward that I had inherited from him, and all sorts of horrible things like that. He was suspended for 2 years by the Supreme Court.
Is there language in one of those opinions? I'm just trying to think of where we can capture some language that might be someplace else, whether it's in a PCR case or in a discipline opinion that sort of confirms that it is an accurate statement of law to send to fail to obtain all the discovery, lawyer review it themselves and lawyer not review it with client to the extent client wants to review it.
Yeah, I'm looking up the case right now.
I wonder if maybe Nora's point earlier about not writing to the exception is well taken, and what we ought to, rather than wordsmith this too much, that's something to keep in mind for our what ends up being our preamble. You know, these are some of these are aspirational. We also recognize that there will be situations where the lawyer makes reasonable efforts to, you know, meet all standards, but due to specific client circumstances, does not. And yet, you know, essentially sanctioning those exceptions without writing to the exception.
Right. I just don't think it would be a violation of a standard if a client was like, I don't want to see X, Y, and Z. Nobody's going to say, well, you should have forced your client to watch it or to see it or whatever. You know, you're following your client's direction.
Right.
And, you know, as a practice tip, if your client is saying that, note it in your file. Right.
I agree with that, but I think that has moved away from what I think I had tried to identify as my concern is things that in my discretion I have identified, like extraneous body cam, dash cam on the way there, things like that. I just still feel like this standard would say that you are in violation if you do not review that with your client. And if you have made that call that I don't need to spend 20 minutes watching a police cruiser approach the scene, you would be failing to meet the standard if you did not watch that with your client.
Well, maybe it's making available and going through all relevant, instead of saying attempting to go through. You must go through all relevant and you must make available all. Does that, seems like maybe
Right.
Nora, you think no.
The issue I see there is that it then, well, I think the point, you know, I understand the point about body cam, about 20 minutes of a police cruiser going down a road may not be relevant, but there are also situations where a lawyer may think, well, this isn't a relevant piece of discovery, so I'm not going to go over it with my client. And then it turns out that there is something in there that only the client would identify as being important and that we might miss, right? And so I guess I am leery if I'm thinking about writing these standards to kind of like the lawyers who want to do the least, that giving them the option to say, well, it's not relevant. Again, we're in a situation where the lawyer could be like, well, I just showed them the probable cause affidavit because nothing else in the police report seemed relevant and it seemed to really capture it. Do you know what I mean? Like it, or I didn't show them any of the body cam because, you know, I didn't think it was really relevant and I summarized it for them. I just worry about having that much discretion in the hands of the lawyer, if that makes sense. And, you know, I think there have definitely been times in my practice when I have missed something and the client says, oh my God, that person standing back there, I know that person, they, you know, they said something to me afterward and maybe I wouldn't have taken note of that bystander because it didn't mean anything to me. Does that make sense? And so there are things that only the client can know that they can pick up on in something that we may not think of as being relevant. And so I just, again, I'm sort of trying to like, and I think I'm trying to make these standards in my mind so that there isn't room or a lot of room for a lawyer who's not so interested in zealously representing their client to tell them that they actually have to do the things. And I understand the concern about like, well, what if I don't show my client the 20 minutes of, you know, the cruiser sitting on the side of the road? It's not capturing anything. I'm not really sure. I don't know. how to, I guess my answer is I don't know how to capture that. I don't know if it, you know, that is something that maybe we can address in the preamble, but I am distrustful, I guess, at the end of the day.
I'm wondering if looking sort of future forward in the standards, there's a whole section called Standard 1.3 Obligations of Defense Counsel regarding, oh, sorry, that's not the right one. Client contact, Standard 2.2, Client Contact and Communication, which has a lot of very specific language about, discovery, obtaining discovery, being, understanding it, as well as the client's information. I wonder if this discussion or language if there can't be additional explanation, if we want concrete information included into that. Because there's this under sub 7, a lawyer should use any contact with client as an opportunity to gather timely information relevant to the preparation of the defense, including, and then it talks about talking with your client. I don't know if leaving the language as we've discussed in the first section and then including this alleviates your apprehension, Nora, or if you want it in both places, or
Which standard were you looking at, Liz?
what am I
I
looking
think
at now?
it should be on the screen now, I think.
No, in
2
the
point, looking forward in it, Standard 2.2,
oh, okay.
which is titled Client Contact and Communication. Sorry, I have them up on a separate
Sorry, I thought
screen
you were
so I
looking
can
at
make
the-
them big enough to read.
I thought you were referencing the rules of professional conduct.
I'm sorry, I wasn't clear.
No, that's okay. To me, that's related to, but separate. Related to reviewing the discovery, but not, there's not a complete overlap.
Oh, I agree.
Yeah.
That it does overlap.
It does.
And there is a section about provide the client information, and there's a non-exclusive list. Now I'm looking at 6B. That says provide the client information, including but not limited to. And it sort of has some specific examples. And I wonder if adding more specific language into that about discussing or making available, providing discovery, to the extent the client, wants to, however we want to phrase it. But I wonder if adding, because what I'm hearing from you, Nora, is that you really want to emphasize that reviewing discovery with the client is one part of their job, and two, might actually help them find a defense for their client.
Yeah.
And so reiterating it multiple, or at least repeating it, might help emphasize what you're asking. And it gives us a space where we can be more specific about what we mean,
Mhm.
as opposed to the language in the first section, which is a little more general as sort of the role of defense counsel. And I don't know if that would resolve, or if you wanted in both places, or if that would resolve your concerns, or how we want to do that.
I think it's a good idea to emphasize it. I'm looking at the phrase that is causing heartburn, the including going through all discovery material. What
Sorry.
if it
Sorry, what
just
are you saying,
said,
Rick?
what if it just said reviewing, including reviewing discovery?
So just instead of going through all discovery material, including reviewing discovery with the client.
Just put give the client information necessary, including reviewing discovery with the client and reviewing discovery with the client and making discovery available. Something about making discovery available to the client for their review, like if they want it. I'm not wordsmithing this very well, but would, if we took out the going through all and put reviewing discovery material with the client, does that?
That alleviates my concern of just, I think just
Okay.
the all word
Mm-hmm.
feels very rigid,
Mm-hmm.
but I do get and agree with your points about not making the rule to the exception and not allowing too much discretion, because then it becomes a standard with no
Right.
enforceability, and it's not a real standard. Then that doesn't mean anything, and there's no point in doing it.
Mhm.
And so I guess if we just remove the word all, but there's certainly an implied this should be all, but if there is some small discretion you choose to not, for whatever kind of just the pointless dash cam stuff, I
Mhm.
think that's workable.
Could just saying making available and reviewing discovery material with the client.
I think
that
that makes sense, because that, like, this is the section of the role of the attorney, and that really is the role of the attorney.
Yes.
And then if we want to add different other additional language
Yes.
further down, we can do that, where it's more like, okay, now we're into the nature of, more specifically of what's happening.
Right.
Great.
Good.
Well, made it through 1/33 of the document today. Great. Well, I know it's almost 10 and people probably have to jump off. Do y'all still want me to keep sending doodles? Would it be easier if we just knocked out this time every week for an hour and tried to get through more? Or better to do doodles? Everybody's schedules are changing every week.
Yeah. Liz,
Okay.
I know I owe you an email.
I know. Well, I thought I owed you an email, so whatever.
We
We'll
owe
figure it out.
emails, apparently. Yeah.
Well,
Thursday mornings are not great mornings in Multnomah County.
Oh,
Just
there's a big
as a,
call.
yeah. So as a standing one, it would be very difficult.
Yeah, and it's one of our 2 trial days in Clackamas County. So.
Got it. I will send more doodles. I appreciate everyone's time. If other people who haven't yet want to look at the Dropbox document, and you could just drop comments on there that might focus our conversation in the future. But also, I know you're all very busy, so also happy to keep doing it this way if that's what ends up working best.
Sure.
So again, I appreciate it, and look out for another scheduling email from you soon.
Nora, can I call you in like 5 minutes?
Yes, you can.
Thank you.
Yeah.
Thank you.
All right. Bye, everybody.